As regards the case law concerning cartels, there are only a handful of decisions that have been adopted from the very beginnings of functioning of the competition law in Croatia. As you can imagine, these were all rather small cases. One of the so cartel cases are scarce in Croatia. That doesn't mean that cartels do not exist, but have simply not been detected. And then you have perception in the public and among entrepreneurs that cartels are simply something almost permissible and normal, and this is something that needs to be changed in the future. Recently, the agency adopted the decision on the newspapers publishers cartel, where the smoking gun evidence was essentially text messages exchanged by executives of two newspapers, where they agreed on raising prices for weekly newspapers for 2 kunas, and this decision was indeed applied as of the next issue. The agency adopted the decision establishing the breach. However, as the procedure has been initiated under the old 2003 Act, it was in the hands of the misdemeanor courts to levy the fines. So we do not expect that substantial fines will be levied here. Other cases relate to, for example, property management companies that have decided to raise prices for 20 lipas for a square meter. Then you have a famous bus operators cartel, where there were 17 bus operators agreeing to fix prices of bus tickets from Zagreb to Split, Šibenik, etc. The mining operators cartel, backing down from the 2005, etc. All of these cartels had explicit collusion or evidence of written agreements handed to the agency, so there were not much of an investigative work was required. So everything was basically handed to the agency. The trade associations had a very important role in all of these cases because majority of them were under auspices of the trade associations. Many of the entrepreneurs or undertakings made some self-incriminating statements claiming that it was the crisis period and what should have they done. So you can conclude that there is not much case law on this subject, and there are no cases under the new 2009 Act. Because all of that leniency which was introduced in the new Act was thought as something that will resolve the issues in a different manner. So this is a new concept in Croatian legislation. The regulation leniency fairly corresponds to the Commission notice. We have the immunity, reduction of fines, everything that was already mentioned both by Mark and Gabor. There is a corporate statement which can be provided either orally or in writing. We have a marker system where you have a provision that in case that the applicant does not provide evidence within the deadline set by the agency can freely dispose with the evidence provided to the agency. So this may be something that potential applicants should bear in mind. We have conditional final immunity. Unlike the Commission notice, Croatian regulation does not provide for leniency in hypothetical terms. All in all, wide discretion has been afforded to the agency. As there is no case law under the new Act, it remains to be seen how the agency will implement the rules that are brought before them, and how the evidence will be evaluated, for example, in cases of reduction of fines when you have to prove the significantly added value. It remains to be seen how the agency will evaluate whether this has been sufficient or not. There are some news on the horizon. There is a currently ongoing change of the criminal or penal code. The current draft provides for criminalization of cartels and bid rigging. Now it seems that it will be expressly introduced, and such draft provides for imprisonment from 6 months to 5 years. and provides for possible immunity for a person who voluntarily reports such a criminal deed. As this is still a draft, it remains to be seen whether such a draft will be adopted and in what substance. In any case, it will be interesting to see how this will all, how the Competition Act will be coordinated with the penal or criminal code. If we take a look at the International Competitions Network and prerequisites for adopting an effective leniency policy, which says that you have to have high risk of detention, meaning that the anti-cartel activity of the enforcement agency should be sufficiently active and that it should have a strong enforcement program, that you have to have a significant sanctions and sanctions that are predictable to the degree, bearing in mind that these are not only the maximums prescribed in the statute, but rather sanctions that are really imposed. So, of course, that the value of the cartel to the participants should not be higher than the fines imposed, so that the fines are not viewed just only as a cost of doing business. In addition, the concept of penalty should be taken into account, not only the administrative penalty imposed by the agency, but also some social implications, retaliation within the industry, customers, whether there are any follow-on proceedings that we were talking about, individual liability of the executives, etc. And finally, that these programs, the ICN states that these programs should be transparent and predictable and certain. When we take a Croatian picture of the leniency programs now, I think that we can come to a conclusion that still there is no much room for the effectiveness of the leniency now, but things will hopefully change, and we'll see whether the leniency options will be attractive for the members of the cartel. If you don't have hefty fines, there is no much incentive for cartel members to apply for leniency. However, then this may be applicable for the cartels operating in a single jurisdiction. But as Gabor said, Croatia, like Hungary, will usually be a recipient of leniency applications as a result of a spillover, frequently taking place in similar cases. Like some other countries, the Croatian regulation also provides that the applicant should disclose whether the leniency application has been or intends to be submitted somewhere else. We do know that the competition authorities do cooperate, and there is a tendency to circulate even sensitive and confidential data amongst them in order to fight against cartels. There will be also potential problems, if you have incompatible conditions imposed in various jurisdictions. For example, one jurisdiction will require that the participant in the cartel immediately stops with the cartel, while another will require him to continue with the activities so that the agencies can perform better dawn raids, etc. So it will be very interesting to see how things will work in Croatia once we finally receive some leniency applications. I think that instead of a conclusion, we can all agree that even the hardcore cartels are considered to be the most egregious competition law offense, and the leniency considered to be the most effective tool. Still, you cannot rely on others to fight against cartels. So we do expect that the agency will try to achieve a credible enforcement record, which is required from the European Union, as the ambassador mentioned earlier in the morning, and definitely it is expected to grow. We will see who will be the first. We can just imagine that this will be one of the cross-border cartels involving a foreign participants.
Yeah. It's if you've seen sort of the things that happened in detergents, that might be sort of a likely candidate.
Yeah.
Okay, Katarina, thank you very much. I think excellent introduction.